process flawed or unconstitutional. Such an inquiry will involve a careful review of the actions taken by the National Assembly and the Senate to determine if the principles of due process and fair administrative action were upheld. We take the view that, based on a holistic reading of the 2010 Constitution, the political question doctrine cannot oust this court's jurisdiction as granted under Article 165, Sub-Article 3. Article 165, Sub-Article 3 confers upon the High Court the authority to hear and determine questions regarding the interpretation of the Constitution and the legality of any acts or omissions by state organs. This provision underscores the High Court's critical role in ensuring constitutional compliance, even in politically charged matters. The Supreme Court of Kenya in Sonko case supports this position in its holding that impeachment proceedings are inherently political. They do not fall beyond the scope of judicial review. The court stated as follows. It's a fairly long quote. I've given it. In Martin Nyaga Wambora versus Speaker of the Senate, the Court of Appeal also held that judicial intervention in impeachment must be exercised cautiously. While conservatory orders may be issued to protect constitutional rights, they should not encroach upon the legislative process unless clear evidence of constitutional or procedural violations exists. The court underscored that judicial intervention should respect the separation of powers, ensuring that the judiciary does not undermine the functions of elected bodies. South African courts have similarly addressed the scope of judicial intervention in impeachment process, emphasizing the balance between constitutional oversight and respect for the separation of powers. A notable example is Economic Freedom Fighters versus Speaker of the National Assembly and others. This is a 2018 matter which involved impeachment proceedings against former President Jacob Zuma. In this case, the Constitutional Court affirmed that while the judiciary has the authority to ensure that impeachment proceedings comply with constitutional requirements, it must exercise restraint to avoid encroaching on the disciplinary functions of the legislature. The court made it clear that judicial intervention is warranted only when necessary to correct political procedural irregularities or constitutional violations. The ruling highlighted that conservatory orders should be applied with caution to prevent unwarranted intrusion into the legislature's domain. The court had this to say, in quote, "Courts must be careful not to impose themselves in a matter that disrupts the legislative process or undermines the authority of Parliament. Judicial oversight is essential to safeguard constitutional rights and ensure procedural fairness, but it should not extend to directing how the legislature carries out its internal disciplinary proceedings unless there is clear evidence of procedural defects or breaches of the Constitution." This decision underlines the principle that the judiciary's role in impeachment matters is not to take over legislative functions, but to ensure that such processes are conducted in a manner that respects constitutional norms and procedural fairness. It reinforces the idea that while the doctrine of separation of powers is crucial, it does not preclude judicial oversight when fundamental constitutional principles are at risk. It is therefore our finding, based on the above, that the Constitution of Kenya has clearly delineated independent and distinct paths for the three arms of government. Accordingly, this court's intervention in the matter before it is warranted through a very narrow window that allows for oversight in cases where constitutional infractions are alleged in the impeachment process. This position is reinforced by our previous determination that the petitioners have established a prima facie case in the petitions before this court.
And I will handle that issue. That is all. We adopt that discussion as part of this ruling by your reference, and suffice to say that the three main principles for consideration are as follows. The first one being that the need for the applicant to demonstrate an arguable prima facie case. The second, whether the public interest will be served or prejudiced by a decision to exercise discretion to grant or deny a conservatory order. And the third is that whether, if an interim conservatory order is not granted, the petition or its substratum will be rendered nugatory. We will consider the court on the material presented to court. A tribunal properly directing itself to court. A tribunal properly directing itself will conclude that consideration. End of quote. This court has not deviated from the above position. We reaffirm that the consolidated petitions in cohort number 1 and in cohort number 2 still raise constitutional issues requiring further judicial interrogation. Court addressed the executive with part 1 thereof focusing on the president and the vice president. Section 4 of the 1963 Constitution established the office of the president as follows. I quote, "There shall be a president of Kenya who shall be the head of state and commander-in-chief of the armed forces of the republic." End of quote. Section 6 addressed a vacancy in the office of the president. Of the 1963 Constitution dealt with the office of the vice president. This one I will read. Of Kenya, who shall be appointed by the president. Subsection 2, the president, of the president. Article 147 provides for the functions of the deputy president as follows. The deputy president shall be the principal assistant of the president and shall deputize for the president in the execution of the president's functions. 2, the deputy president shall perform the functions conferred by this constitution. We emphasize that. The deputy president shall perform the functions conferred by this constitution and any other functions of the president as the president may assign. Subject to Article 134, which deals with temporary incumbency, when the president is absent or is temporarily incapacitated, and during any other period that the president decides, the deputy president shall act as the president. And sub-article 4 says that the deputy president shall not hold any other state or public office. It is therefore beyond any peradventure that the role of the president's principal assistant changed significantly in the 2010 Constitution compared to the position of the vice president under the 1963 Constitution. Some of the notable changes include: 1, whereas the vice president was solely the principal assistant of the president, the deputy president is both the principal assistant of the president and also deputizes the president in execution of the president's functions. 2, the deputy president performs specific functions conferred by the Constitution. 3, the deputy president may perform any other functions of the president as the president may assign. 4, unlike the vice president who was appointed by the president from among cabinet ministers who are elected members of the National Assembly, the deputy president under the 2010 Constitution is elected together with the president and holds no other public office. The above changes were not without reason. In the book, The Constitution of Kenya, commentary by Louis and Piero Lumumba, this is the second edition, Strathmore University Press, there 2019 at page 453. The two eminent authors had this to say, and I quote, "With the other arms of government considerably weakened, the executive personified in the president exercised unchecked powers. Indeed, during the constitutional review process, the CKRC noted that the powers granted by the Constitution and the ordinary laws to the elected president seemed to share characteristics with those of the colonial governor. It then resolved during the constitutional making process to divest some powers from the president with the aim of avoiding an imperial president." End of quote. The above cannot be far from the truth. In the pre-2010 constitutional era, the president held immense powers, including the ability to appoint and dismiss the vice president at will, and the discretion to assign or to withhold duties for the vice president. Consequently, the vice president served entirely at the president's mercy. That was the framework that the 2010 Constitution sought to transform. Under the 2010 Constitution, the office of the Deputy President has been fundamentally redefined. It is now safeguarded from arbitrary and capricious actions by the President. Article 172 grants the Deputy President specific constitutional functions, in addition to any duties the President may assign. This provision was intended to address the previous situation in which a President could, for any reason, choose not to assign any duties to the Deputy President, effectively sidelining them. Thanks to the 2010 Constitution, even if the President does not assign any additional duties, the Deputy President still has specific constitutionally mandated functions to perform. In this way, the Deputy President is no longer at the mercy and the discretion of the President. Under the current constitutional framework, when the office of the Deputy President becomes vacant, two outcomes flow. First, any functions that were assigned to the Deputy President by the President automatically revert to the President. Second, the functions expressly conferred upon the Deputy President by the Constitution do not revert to the President and cannot be performed by anyone else. This is a departure from the 1963 Constitution, under which the President could appoint a minister to act as Vice President in the Vice President's absence. The 2010 Constitution includes no such provision. Therefore, if the office of the Deputy President is vacant, the specific constitutional functions assigned to that office remain unfulfilled. For clarity, not even the Speaker of the National Assembly may discharge the functions vested in the Deputy President under Articles 147, Sub-Article 2 of the Constitution. In light of the above, we are convinced and hereby find that the current constitutional framework does not envision any scenario in which the office of the Deputy President would remain vacant, except during the brief period required to fill such a vacancy. Another equally important provision that adds credence to the above position, that the office of the Deputy President cannot be left vacant, is Article 146(3) of the 2010 Constitution. However, before we interrogate the said provision, suffice to note that Article 150, Sub-Article 2 of the Constitution, which is on the removal of the Deputy President, has it that the provisions of Articles 144 and 145 relating to the removal of the President shall apply with the necessary modification to the removal of the Deputy President. Returning back to Article 146, which article deals with the vacancy in the office of the President, Sub-Articles 1, 2, and 3 of that article provide as follows. This one I'll read. Sub-Article 1, the office of President, Deputy President, shall become vacant if the whole of the office A, dies, B, resigns, in writing addressed to the Speaker of the National Assembly, or otherwise ceases to hold office under Article 144, which deals with removal of President on grounds of incapacity, or Article 145, which deals with removal of President by impeachment, or under any other provision of the Constitution. Sub-Article 2, when a vacancy occurs in the office of president or deputy, 1, the deputy president shall assume office of the president for the remainder of the term. 2, if the office of the deputy president is vacant or the deputy president is unable to assume the office of president, the Speaker of the National Assembly shall act as president, and an election to the office of president shall be held within 60 days after the vacancy arose in the office of president. Sub-article 3, a person who assumes the office of president under clause 2A or following an election required by clause 2B shall, unless otherwise removed from office under this constitution, hold office until a newly elected president is sworn in following the next regularly scheduled election under Article 136, Sub-article 2A. End of Sub-article 3. Therefore, to us, a holistic reading of Article 146 alongside Article 152 of the 2010 Constitution, and in relation to the filling of a vacancy in the office of the Deputy President in this matter, yields the meaning that the person who assumed the office after the impeachment of the Deputy President shall, unless otherwise lawfully removed from this office, hold that office until further orders of this court or until the current term of the President ends, whichever comes first. The foregoing demonstrates that the structure of the Constitution, which reflects the popular will of Kenyan citizens, envisions a scenario in which the office of the Deputy President will always be filled except during the brief period of required to fill the vacancy as already stated above. Based on the foregoing, we now turn to the nature of the conservatory orders in this matter. It is what the purpose of conservatory orders is to preserve the status quo pending further orders of this court. The Supreme Court in Gachagua, Peter Munya, and Dixon Mwanda Withinja and 2 others say as much. In this case, maintaining the status quo would mean, 1, that the first petitioner remains impeached under Article 145, sub-article 7, which affirms the finality of the impeachment process with the following provision, I quote, if at least 2/3 of all members of Senate vote to uphold an impeachment charge, the Deputy President shall cease to hold office, end of quote. 2, additionally, the prevailing status quo will mean that the Deputy President nominee, Professor Abraham Kithure Kindiki, does not assume office. With such an approach, while such an approach may seem fair, reasonable, and balanced, and one which this court would ordinarily be inclined to adopt, the unique nature of the Deputy President role under the 2010 Constitution suggests a different course. Allowing these orders to stand will leave the office of the Deputy President vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the Deputy President under Article 147, sub-article 2, once those assigned by the President revert to the President in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution, an outcome that no court should knowingly permit. For clarity, this court firmly holds that no court should issue orders that have the effect of suspending the operation of any provision of the Constitution, such an outcome is clearly not envisioned by the document itself. The Constitution was not handed to Kenyans on a silver platter. No, it was achieved through great struggle and sacrifice. Therefore, it is the duty of the court to uphold its provisions as intended by the framers and as demanded by the people of Kenya. Furthermore, Article 259 of the Constitution mandates that the document must be interpreted as always speaking. This means the Constitution is a living document designed to address contemporary challenges and to be applied consistently and continuously without interruption. Suspending any provision of the Constitution, even temporarily, would undermine this principle by creating gaps in its operation and disrupting the intended balance of government. governance. The Constitution is structured to ensure that all its provisions are effective and operative at all times. If any provision, such as Article 147, Sub-Article 2, is rendered dormant by a judicial order, it risks setting a precedent where parts of the Constitution could be selectively switched off, effectively weakening the Constitution's authority and the protection it affords. Additionally, we are mindful that courts are guided by the principle of constitutional supremacy, which requires that all judicial decisions align with the Constitution's objective and upholds its integrity. Issuing an order that suspends a constitutional provision would directly contravene this principle, effectively placing judicial discretion above the supreme law of the land. This would be inconsistent with the spirit of judicial restraint and the court's role as a protector and not a modifier of the Constitution. For these reasons, we take the position that the Constitution must remain fully operational at all times, and no court order should have the effect of rendering any part of it inoperative or dormant. The court's responsibility is to interpret and apply the Constitution as a cohesive functional document that serves the people's enduring will and protects the structure of governance as established. Drawing from the above, we hereby find and hold that public interest in this matter favors giving way to the Constitution, which in any event is the will of the people. That is also the dictate under Article 3 of the Constitution, where every person has an obligation to respect, uphold, and defend the Constitution. We choose to abide by that calling. As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the consolidated petitions will be rendered nugatory in the absence of any orders. As we stated in ruling number 1, because the consolidated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation. The next issue is whether the applicants will be prejudiced if the orders are not granted. Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process to unfold does not in itself result in detriment, as it upholds the rule of law and respects the framework agreed upon the people. The applicants also urge the court to grant the conservatory orders, expressing concern that the respondents have a history of disobeying court orders, and that once the office of the Deputy President is filled, it will be impossible to remove the appointee, even if the petitions were successful. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience of court orders. Moreover, the Honorable Attorney General, through Senior Learned Counsel Professor Gitu Mugai, has given an undertaking to comply fully with any orders which will be issued by this court in this matter. As such, we find that the applicants do not stand to suffer any prejudice in the event the conservatory orders are not granted.
This position, as we conclude, to an expeditious examination of the petitions. Therefore, we will further provide directions within forthwith be uploaded in the court.
The common law is called the Perry-Ford injunction. The mother paper injunction operates on quite a simple premise. The premise of human affordability. In the case of Perry-Ford, where that injunction originates, Justice Maker, after dismissing an application for injunction like you have now, found still that there could be the slightest chance that he was wrong. Yet, there could be the slightest chance that you are wrong. Last week, this court gave the Deputy President leave to appeal We thank the court for that generosity. The Deputy President has appealed. He also has pending before the Court of Appeal an application for stay of these proceedings. And that application comes up on the 6th of November 2024. My Lord, operating on the premise of human fallibility, the foundation of the erring code of manifesto injunction, we request you to recognize that you could be wrong. And if you're wrong, then the pending proceedings before the Court of Appeal will be rendered immediately. To avoid that possibility, the possibility that the Deputy President's right to appeal, which you recognized and affirmed and upheld by giving him leave to appeal, even when employee needed none, we ask you to issue a non-paper injunction. We do not seek an indefinite injunction. We seek an injunction until 6th of November 2024, when we are next before the Court of Appeal. Thank you, Lord.
We also have a moment by the chair.
The black rule, okay.
My lords, I want to associate myself with the submissions made by my learned friend, and also state that I have listened keenly to the ruling that has been delivered by this honorable court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows, therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. And as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I rise under Rule 23. The determination of this application done under Rule 24, that this Honorable Court does issue conservatory orders suspending the swearing in of Professor Kithure Kindiki on the following grounds. Your Lordship, Article 10 of this Constitution, of the Constitution, binds this Honorable Court to observe the rule of law. It further calls upon this Honorable Court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission, Mr. Jero has referred to an application for which we're seeking some orders pending, but we haven't seen any application in that regard.
Yes, Your Lordship, if Mr. Kamoso was keen to read the rules, the Mutunga rules allows me to move you informally. And subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion
or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Lordship, that the court...
If I may, I respect my learned friends. My Lord, I respect... Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either is referring to E554, E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my learned friend is referring to the exercise of this court of a epistolary jurisdiction, then you should say so. But you cannot refer to the exercise of that jurisdiction, my Lord, when this court is functus officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for stay under Section 5(2)b of the Advert Institutions Act before the Court of Appeal that is live and that has a date. This court would not have jurisdiction to entertain any other application for stay. They tried making an application before the Court of Appeal this morning using the same issues, my Lord, and the Court of Appeal rejected the application. They were told to serve everyone else. So, my Lord, for my learned friend to come here and to seek to apply for stay again, having a second bite at the cherry, is dishonest, my Lord. It's dishonest. They are before the Court of Appeal.
So, may I suggest, Professor Jenda, that could be your response to the application which will be made by Ndegwa?
Yes, if there's an application.
Thank you, Your Lordship. Your Lordship, permit me to move on with my application. And I ask Professor Ojenda to have a look at the rules that I have just referred to. That, Your Lordship, you be kind enough to interrogate the circumstances under which that office shall be filled. Your Lordship, it is on record, and I invite the court to take judicial notice, that there is a clear non-existence of a crucial state organ that is supposed to oversee the processes of filling of that office in the name of the Independent Electoral and Boundary Commission. Your Lordship, the Independent and Boundary Commission is created under Article 88 of the Constitution, and the functions are created therein. One of the functions, my lady, is to maintain a voters register, is to register voters. Under Article 99, Your Lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the President or the Deputy President must attain if one is to hold office. My ladies, my lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies, my lords, that a deputy president designated or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kithure Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, Your Lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Your Lordship, the President indicated that he has had confirmation that Professor Kithure Kindiki meets and meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. Ladies and lords, when the President of the Republic referred to the IEBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. But ladies and lords, it's my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC. All know, my ladies, my lords.
My lord, may I kindly seek your guidance? When Mr. Giro started off, we thought it would be a simple and straightforward application. But now, seeing the trajectory it has taken, he has raised a number of issues for which he would require them reduced in a particular format so that we can seek instructions from our clients. So we're seeking that we get a formal thing that will enable us to seek instructions.
Remind me your name.
Dr. Kamodo, for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IPC to confirm whether Professor Kithure Kindiki is a registered voter, that would mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordship. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Njero, my understanding, when you first asked for this conservatory under Madu paper,
yes, sir.
It was...
That is his application.
Yeah.
I am on a different application. I moved on that
because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal but also very short because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another big application.
I am well guided.
So I think for the purposes of the discretion of the bench, for the purposes of the discretion of the bench,
yes,
I think Mr. Ochieng's application is what we should be considered. Your application evidently requires to be formal.
But the court also needs, not this court, not myself, nobody can bury his head under the sun, that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the sovereignty of the people? Your Lordship, I beg that you hear us. I beg that you grant the conservatory order staying the swearing in of Professor Kithure Kindiki on the basis that he has not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you will be inviting us to say.
Let me respond to...
So that Professor Agenda and every other council who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretional. So I'll only allow one response, only one response, and then we'll render a ruling. Only one response.
Yep, my Lord, if I may.
Justice Eric Ogola. Justice Anthony Gorima. I think Justice Frida Mukangi. I'm listening to what you have said very carefully. And from my point of view, one would be interested in developing the students of the country. You have done so. You have developed. But there is one thing I would like to point out to you very respectfully. That you are operating in very dangerous waters with strong currents. And this is an area where we have to call for wisdom, we have to call for deeper understanding of human nature, and for deeper understanding of the society in which we live in Kenya. And what I'm saying to you is reflected in my broad feelings of the authorities in cases in the United States of America. Your Honor, if I may say so with respect, perhaps more than anybody else, when I was engaged to get involved in this case, I ordered for book from immediate straight about the legislative authorities on impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully how will this judgment be received by the people, by the consumers. How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling will continue to promote stability in the country? And it's here that I'm inviting you very respectfully that you consider the table remarks of my own friend, that we should not, and Grand Prime Minister is here, we should not ignore what they are saying back here. With a tremendous respect, we don't want to move out of this courtroom and then all of a sudden we are told that there are protests now in I'm not trying to use the game with your disorder. All that I'm saying to you,
Sorry, my lords. the utterances by Honorable Dr. Camino I'm giving you the title.
No, what I'm saying,
unfortunately, they decide they are trying to preempt matters that are not before this court. We do not know and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. And unfortunately, my lords, I ask you to kindly restrain me from taking that route.
Your kind permission, Your Honor.
Please sit down. Please sit down. We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dudley Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
I'm not asked to you indicated that two people are prepared to make an application.
Continue, Dr. Kamuna.
I'm actually so in one sentence. When you read the brief, I have referred to the authorities in America. The judges have made a finding along these lines. Yes, this is a legal so and so, but we shall not go ahead. We shall be ready. So that's all I'm saying to you. You have heard, you have come that very family say so. A ruling of the students and particularly my mind is Lord has come up with something that I had not thought of very much. But all I'm saying to you that you are different, you still have the to say that look, we are not, we have fixed our findings, but still we are going ahead with you for the order for so many days or so many weeks. So, you still have that discretion for the sake of the country. Thank you.
Well, my Lord, in brief response.
I appear for the 9th petitioner in the second cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling order, Lord, we wish to move the court much as we have that opportunity by way of the orders that were given, that we were given right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord and my Lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition we have named the Professor Kithure Kindiki as a party in the petition that we had filed for the 9 petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time, when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the 9th petitioner who has moved the court. And, my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill up that position of the Deputy President. So that, my Lord, there is no any prejudice that will be occasioned to the second respondent if the orders of stay gets issued, because by close of business today, my Lord, we are going to lodge the notice, and that notice by itself acts as an appeal, and in the fullness of time, we shall be processing the application before the appellate court for appropriate orders to issue. My Lord, I therefore associate myself with my colleagues on the application for stay, so that we don't have the proceedings before you in the fullness of time when we come to canvass the petition to be rendered nugatory or academic. My Lord, you have the discretion, and we ask and beseech you to exercise that discretion in the favor of the 9th petition. Thank you, my Lord.
My Lord, for your ruling today and the lengthy explanations and court case that was going into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us in this matter, which is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024, and we thought that we'd be enjoying as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November. So at least we get a fair chance, a fair fighting chance, as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that the other side has asked for 7 days to appear. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners, and others will just be thrown under the bus and into the darkness.
Just a minute.
Clarify that.
Can you just clarify your application? You say is dated the 8th of October?
8th of October, 2024.
What is the substance of the application?
It's petition E541 of 2024. We're seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
We are not happy with your current petition.
Let me clarify. Is that the matter which you are hearing with Dr. Mosa?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you I did that and you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are